project done by my group, obviously from Nicole Goins, Howard Bailey, Seth Ford, and myself. All right, so in this presentation, we're going to talk about 7 different topics. The first one is religion in public school. This involves aspects of religion, but includes prayer and Pledge of Allegiance. A decision in the U.S. Supreme Court in 1962 created the Establishment Clause. With the Establishment Clause, Congress shall make no law representing the establishment of religion. Free Exercise Clause, Congress shall make no law prohibiting the free exercise, therefore, of. Congress shall make no law representing an establishment of religion or prohibiting the free exercise thereof. That is from the First Amendment of the Constitution, recited in 1971. All right. Second topic, freedom of expression for students. American Civil Liberties Union. They state that you have a right to express your opinions as long as you do so in a way that doesn't materially and substantially disrupt class or other school activities. If you hold a protest on the school steps and block the entrance to the building, school officials can stop you. They can probably also stop you from using language they think is vulgar or indecent. To sum that up, basically, as long as you're not causing disruption, the students are free to express themselves. But as long as it's not disrupting school or any activity from the school. Search and seizure. Any item that is considered property of the school can be searched without letting the student or parent know. School staff can give permission to the police to look in your locker or desk even though you use it. Schools usually have a policy on search and seizures, and it must be provided to the students upon request. School staff may search a student if there are reasonable grounds that the search will turn up evidence that the student broke a school rule. That's a big one. So we got to have a witness. We got to have probable cause. We can't just randomly check lockers just on a hunch. So we got to have a reliable source and follow established policies that we've already given to students prior to. It must be justified when it starts and reasonable in how it's done. Factors to include to establish a reasonable search is the child's age, the gender of the child, and the gender of the staff searching the child. I don't think it is ethical to have a male student do a pat down of females if we can help it, just because that's going to open up a whole lot of things we don't want to deal with. And then the rule of law is to believe to be broken. We're not going to search anybody unless we have substantial evidence or a witness comes up to us and says that we may have a problem here. Due process. Procedural due process guarantees that prescribed set of steps will be followed that allow students and school personnel an opportunity to seek redress for alleged violations before any action is taken place against them. The Fifth Amendment applies to states, to the federal government, and the 14th Amendment applies to the states. Okay, so both of them map out what procedural due process is. We've got to have a set of steps that we've got to follow in order to uphold proper due process. Substantial due process ensures that a valid reason exists before an individual is deprived of liberty, life, and property, and that means used to achieve this objective are reasonable. You must have both to have a constitutional requirement of due process. So you have to have procedural and substantive. So we've got to follow steps, and we've got to have valid reasons for both of those. The Galt decision define how school officials must respond to students in disciplinary hearings, and guarantee no student shall be denied personal rights under the 14th Amendment. Gross versus Lopez, students facing suspension up to 10 days or less were entitled to an oral or written notice prior to. So we can't just say, hey, you've been suspended, or hey, you got OSS. They've got to have it in written notice of the charges, and that gives them the ability to repeal that or say their side of the story. The vagueness doctrine, students must reasonably understand what behavior is expected of them by school officials. Again, with search and seizure, with due process, make sure that we give them a set of guidelines and expectations beforehand, before we carry out search and seizure, due process, anything that we're going to do disciplinary. We've got to have prior notice to the students before we carry these things out. Presumption standard, school officials must have a definite basis before they initiate measures to deprive students of their liberty or property interest. All right, liability and student records. Under FERPA, commonly referred to as the Buckley Amendment, was enacted in Congress in 1974 to guarantee parents and students a certain degree of confidentiality and fundamental fairness with respect to the maintenance and the use of student records. Rights of parents. Parents have the right to inspect their child's record. Parent or legal guardians may challenge the accuracy of the information found in the files regarding their child. Consent of the release of student records must be written in form, signed and dated by the consenting parent. A parent just cannot just show up to the office and just say, hey, I want to see the records. We've got to have consent to have the access to these files because of confidentiality. Rights of non-custodian parents. Schools should make educational records accessible to both parents of each child fortunate enough to have both parents interested in the child's welfare. So even though a parent may not live with their child, they still have the same access as a parent that would live with the child. So we should, as schools, provide access to both parents if we can. Rights of eligible students. Students may exercise the same rights if they're 18 years old or older. They waive those rights once they become 18. I know in IEP meetings, I always tell my parents, hey, your child's about to turn 18. These rights will be transferable to the student once they age out. So they will have the same rights as their parents once they become a legal age. Rights of school personnel. Teachers, counselors, and administrators who have a legitimate educational interest in viewing records may do so. This is usually going to be a principal, a counselor, anybody that comes in contact with this student throughout the day is going to have access to this. If it's a student that you don't come in contact with, or you have no special interest in clubs or anything like that, more than likely you're not going to have the right to confidential information. So precedents for liability of student records. As Wasso ISD versus Falvo, Supreme Court ruled that peer grading does not violate FERPA. Student parent papers are not maintained and kept in files or cabinets at schools. So under FERPA, students can grade each other's papers because they are not kept in a file throughout the year like an IEP would be, or a 504. So it's a slippery slope as far as students knowing each other's grades, but it does not violate FERPA. Doe versus Gonzaga, Supreme Court ruled that students and parents may not sue for damages to enforce the provisions of FERPA. In 2002 in Ohio, the Sixth Circuit Court of Appeals affirmed that university disciplinary records are educational records under FERPA, and that disclosing such records without students' consents constitutes a violation. So you have to have educational records that coincide with FERPA. So those are educational records, and therefore they are confidential. All right, so recommendations for liability in student records: have in place policies that are consistent with FERPA. If we don't have policies that that violate the law or a major litigation such as FERPA, we're already setting ourselves up from the word go as far as inconsistent expectations and policies. Keep accurate and maintain records in a safe and secure location. Pretty self-explanatory. Make sure that we have a place that we can keep files that no one has access to, maybe a file cabinet with a key. Maybe it's something that's digital that you have to have a password, but this should not be accessible to everybody. Any adjustments to student records need to be dated, initialed by who viewed them. Keep a log of who has access to that. I know here at my school in our platform, we have to document every time we access student records, so we have a paper trail to see how often this is accessed, and to make sure that we document who is actually viewing these files. If it's somebody that doesn't come in contact with this child, then we are technically breaking the law. Disciplinary records should be specific of infraction with the student present. We should avoid opinion-based statements. Just simply state what happened in the event. If we get to a point where we go into court over this, opinion statements are going to be picked apart by lawyers. So we need to avoid that as much as possible. Avoid confidential and harmful information of students with third parties. I don't know why we would even get to this point, but we should not be discussing confidential information with other adults, other children outside of the school. So we need to maintain professionalism and keep in-house information in-house. And finally, refrain from releasing information over the phone and keep much information as possible in writing. Self-explanatory. If we get to a point where it's a he said, she said kind of thing, you have it in writing, you can pull that up from an email, a document, whatever you need, but it should not be anything over the phone or a voicemail, because those things do get deleted or they get misinterpreted. All right, individuals with disability. The three significant federal statutes, IDEA, Individuals with Disabilities Act, ADA, Rehabilitation Act of 1973, Section 504, three big ones. These are all three outlines of what we can and cannot do with students with disability. We should not infringe their rights, make them any more than what we could see in a general ed classroom from person to person. So even though a child may have a 504 or an IEP, we have to follow this plan to the T. Okay, this was set up by a committee. These records should be confidential, like we covered in liability and student records. The adults and parents that come in contact with this child should be the only ones that we're discussing with committee decisions. So these are the three big ones with federal law with students with disabilities. RTI, Responsive Intervention, or MTSS, Multi-Tiered System of Supports, a multiplier approach for students with deficits and hope to close educational and or behavioral gaps. So this is a measure to gauge where a student is, where they need to be, how can we close the gap with the modifications, the accommodations they're going to get in a 504 or in an IEP. The process. First, you have to have a referral. So if we have a committee, if we have a teacher that's concerned that, hey, maybe this student needs a little more support, needs some documentation to prove that, we've got to have a referral first. A school psychologist will then have some testing done to gauge the eligibility to see if they fall in any eligible category of special ed. If yes, they will have an IEP. If no, we go back to RTI, see what we can do for other supports outside of special services. If the committee agrees that there is an IEP that needs to be created and implemented, we'll go with present levels of performance. What is the student currently doing? To have baseline to create goals for an annual review every year. Responsible in these meetings, we've got to have a general ed teacher, we've got to have an LEA or at least administrator, we've got to have a special ed teacher, usually it's the caseload manager, and we are looking for the least restrictive environment to put these students. We should not just put them off to the corner in their own separate classroom if we can help it. If they can be co-taught in a general ed setting, that's where we need to start. Can this student perform with their peers in the same environment as much as possible before we put them in a separate classroom? FAPE, Free Appropriate Education, Pennsylvania Association for Retarded Children versus the Commonwealth. Mills and Boards of Education are two major court cases that dealt with everything I mentioned above. Children with disabilities have a right to FAPE, and when possible, educated in the general education classroom. So again, we need to find as much as possible to place these children that do have an IEP or have a 504, we need to place them in a general ed setting with their peers if we can help it. All right, and finally, Alabama Educator Code of Ethics. The Alabama Educator Code of Ethics defines the professional behavior of educators in Alabama and serves as a guide to ethical conduct, protects the health, safety, and general welfare of students and educators, outlines objective standards of conduct for professional educators, and clearly defines action of unethical nature for which disciplinary sanctions are justified. This includes professional conduct, trustworthiness, unlawful acts, teacher and student relationships, alcohol, drugs, and tobacco, use or possession, public funds and property, remunerative conduct, maintenance and confidentiality, abandonment of contract. So basically this is the playbook, or I would say the handbook for the entire state of Alabama of how one in education needs to conduct themselves, what they can and cannot do. This is going to be the precedent to be used to see if there's a violation an educator may have done during their career. So that is all I have. Thank you very much.